I'm broadcasting. Still no.
Still no.
Still no. We just see a little blue figure.
What about now?
Now we can. Yay! There we go.
Yay!
All right. There
Awesome.
we go. Okay. The way you've never done this before, so just so you know the way that it works, like when we talk, the camera will show us, and then when you talk, it just kind of activates on your microphone. So, anyway, I want to thank. What do we call? Do we call you? Can I call you EJ?
Yeah, that's fine.
What is the proper term for you?
That's proper. I've been called worse, so that's
okay.
fine.
Fair enough. Okay, this is EJ. I'll let you introduce yourself to the class. This is my debate class. We're talking a lot about rhetoric and persuasion. So, have at it.
Okay. Well, my name's EJ Overson, and I'm an attorney with the law firm Bishop and Lay down in southern Utah in Cedar City. And I have been an attorney for 5 years now. And I went to law school at Michigan State University College of Law in East Lansing. And prior to that, I went to Southern Utah University and got my undergraduate degree there.
We had one person just say, "Go Spartans." So.
Yay, Spartans! That person gets an A.
Had a good game last weekend too.
Yes. Yes.
Anybody that beats Oregon's cool.
Yeah, he said anybody that beats Oregon's good in his book. So. All right, so tell us a little bit about normal day-to-day stuff. How does your job work, and kind of like how does language and rhetoric work with your job?
Okay, well, so I guess basically as an attorney, it's a lot different than, say, a lot of the channels that you see or movies that you see where attorneys are always in court. Attorneys aren't in court as much as probably society thinks they are. However, I'm always doing work. And so a lot of the work that I do, even though I'm not in a court setting, it's with pleadings or briefs or writing memorandums and things of that nature. So I use rhetoric and, language and persuasion probably every single day. But a majority of the time, I guess, when you think of persuasion and you think of rhetoric in a legal setting, you're thinking of, standing in a courtroom setting. You've got the adversarial process working. You have, if it's a criminal case, you've got prosecutors against criminal defense attorneys, or if it's a civil case, then you have one attorney pitted against another attorney. And then the judge is ultimately the final decision maker, and he decides based on the law and based on the arguments of the parties, which party is going to prevail at the end.
Okay. Now, so we see a lot, like you said, in movies where it's like trying to persuade a jury. How often is that the case?
Well, jury trials, obviously in a criminal setting, jury trials are more common, but they're not as common. A lot of criminal cases in today's age are settled. They're resolved either by plea agreement, or sometimes they can be dismissed in its entirety, depending on the lack of evidence or depending on an agreement by the parties. But a lot of the time, if you have juries involved, generally speaking, it's few and far between. I myself have only been involved in one jury trial in 5 years of practice right now. Wow. So that gives you kind of an idea that it's rare. Whereas in the movies or TV, it seems like every case is going to trial and the juries are always there. But that's not so much the case, at least in my practice, it hasn't been.
What's your specialty?
Right now, I primarily do a lot of family law, so custody disputes, divorces, paternity, parent time, things dealing with that nature. And then I do a lot of criminal defense. Mm-hmm. So with criminal defense, I do a lot of plea negotiations, and that requires a lot of persuasion because typically speaking, when someone gets charged with a crime, generally they're betting on the fact that there's enough evidence to convict that person if it goes to trial. And so my job as a criminal defense attorney is to make sure that my clients' rights are protected, while at the same time trying to get them the best outcome if possible.
So we've been talking a lot. I'm down. Get me down here. Okay. It's Bow Tie Tuesday, by the way.
Good bow tie.
Thank you. So we've been talking a lot about the rhetorical triangle and trying to persuade people through emotions, through logic and statistics, and also through like expert opinions. Which one do you find more helpful in your job? I mean, do all three kind of work together, or are you a little bit more leaning towards one or the other?
I'm sure that all three work together at times, but more times than not, it seems that emotion, or perhaps, the persuasion aspect, plays a greater role in what I'm doing or in the cases that I'm involved with. I mean, for example, in a family law case, you could have two sides who are both, equal parents. They're good parents to their kids. But if one side can persuade the judge more that, hey, I should be the primary caretaker of my children versus this other person, then the judge is usually basing it off of persuasion and emotion, not so much the rule of law. Because the rule of law states that any parent, so long as they're helping the best interests of the child, they would be a good primary custodian. But obviously, in today's world, you can't have two primary custodians, because typically when parents get divorced, they live in either different houses, different cities, different states even. And so with that type of argument, the judge has to make his decision based on who persuades him the most, obviously. And sometimes emotions play a role in it. However, on the flip side, like with criminal defense cases, there are times when the rule of law says one thing, but because the criminal defendant has been very remorseful, or they've really attempted to change their life around and they've taken proactive steps in doing so, then the judge will sometimes say, you know what, even though the statute says you're going straight to prison for 0 to 5 years, I'm going to suspend that sentence and put you on probation. And that's generally done because of persuasion or emotion. It's not so much logic or the rule of law, because the judge could easily say, well, guess what? Statute says you're going to prison, therefore you're going to prison. But the judge has a lot of discretion to decide, what he or she is going to do.
Right. Definitely. All right. Akira, did you have a question you want to ask?
I just submitted.
Oh, you submitted a question?
We did all ask questions, actually.
Okay. I've been I had them like type up questions. They all have iPads. So, crazy
Cool.
how life has changed. And
Yeah. That's awesome.
used to tell everybody put their phones away. Now we use them to do stuff with them. So
Gotta say my home name.
where's your question?
It's right there at the top, like second to the top.
I don't know. Someone says, I don't know, you're the one with the Hawaiian sandals. Okay, I have one question. What's the most rewarding part of your job?
The most rewarding part of my job is usually when I have clients who, regardless of what I've done for them, either in a family law case or a criminal defense case, where they either contact me months or years later and say, hey, look what I've done with my life now, or look how much I've improved. Or the other part of that would be if I get referrals from previous clients and they refer family members or friends and they say, guess what? I was told to contact you because you did such a great job with so-and-so. That's probably the best reward, is because then it's not only letting me know that I'm doing a good job, but it's letting me know that, the clients who I've helped, they like me enough to where they feel comfortable referring other people to me. And so it helps me feel like I am making a difference in the world, because sometimes as a criminal defense attorney, the jokes go that we're just helping the bad guys get back on the streets,
Right.
which may or may not be true. But the best part about it is to know that, we're doing something productive and we're protecting rights of every individual that comes into our office.
So Akir's got his question. He's right here. I'm going to let Akir kind of articulate his question.
Gotta go up there.
He can see you. Can you see him?
So my
Yeah.
question, I took a business law class last year, and our teacher kind of explained that you may have a client that you don't totally agree with, but you have to work with them anyway. Like, how do you do that? Because I don't like dealing with people that I don't like, and that's something I need to work on. So how do you do that?
That's a good question. There are times when I've had clients and we have not seen eye to eye. I'll give you two examples. First example, if I get privately retained, that means someone pays me money to represent them. If I get privately retained and me and the client just keep butting heads and we keep arguing and they don't want to accept my advice, then I'll give them a straight up, I guess, what do they call it nowadays? It used to be a DTR, define the relationship type of talk. And I'll say, hey, listen, you paid me to do this, to represent you in this type of matter. This is what I think you should do. If you don't want to do that, you have two options. One, you can essentially fire me and retain another counsel, or two, we can try and resolve this and we can work together because I have your best interests in mind. And generally speaking, clients will say, okay, you're right, and they'll either do one of two things. They'll either say, okay, let's go forward, or they'll say, yeah, I'm going to find another attorney. I have yet to have a civil client or even a criminal defendant fire me and go to another attorney. So I haven't had to deal with that yet. But then there's another example. I was a public defender for Beaver County for a year in 2012. Do any of you guys know what a public defender is?
Anybody that needs you can use you?
Okay, so public defender, for anyone that doesn't know, they're the attorney who's appointed to indigent people in the county, people that cannot afford an attorney, and they're in criminal court. So I was a public defender, and when you're a public defender, you get appointed to anyone and everyone that may qualify to be in your service. And so they may hate you, they may hate the public defender system, but once I'm appointed, I'm their attorney, and there's nothing they can do about it unless they want to represent themselves. So there have been times where I've had public defendants say, you know what, every public defender I've had has been worthless, they're a waste of time, a waste of money, and I don't want one. And so generally what I'll do is I'll say, listen, give me a try, let's go a couple weeks, and if you still feel that way, I'll inform the judge and we can go our separate ways. But again, I have yet to have a public defender say, you know what, I don't like you, I'm going to fire you. So in my experience, at least, I've been able to work out issues that I've had. But you're right, your professor or your teacher that you took business law from, there are times where you and the client, you just butt heads, and you just have to keep trying your hardest. But it's hard sometimes, but generally speaking, you can work through it.
Cool. So we have another question. Especially working for a firm, do you get the chance to choose your cases, or you kind of like handed them?
Both. I'm in a firm with two partners, two older attorneys. So when I first started there, I was new. A lot of people didn't know I was there. So they would hand cases to me, or they would refer cases to me. And so that way it was kind of like, take this so that you can get your name out there. And I couldn't choose a lot of the time. And so I just kind of took whatever came to me. However, now that I've started to build a name, a reputation, I get to choose a lot of my cases, and I have my own clientele. So there's 3 attorneys in this small firm that I work at. We all have our own clientele, but there have been times where the partners say, hey, EJ, guess what? I don't want to handle this case, or I can't handle this case. So I told them that you were going to be their attorney, and I just have to accept it because I'm the grunt on the totem pole. And so it's been good and bad. One experience that happened when it happened, I hated it and I wanted to yell curse words at the partners, but now I've realized it's been a blessing. But I was last year in about April, I was told by one of the partners that I needed to go and argue in front of the Utah Supreme Court in a case. And that's the highest court in our state, the Utah Supreme Court. And you argue in front of, that day there were 7 judges that were on the panel. And I had to argue a case that was one of the partner's cases. I knew very little about it. I did my best, but quite honestly, the judges just ripped through me. I mean, it was horrible. After it was done, I thought, man, why did I become an attorney? But fast forward to just, well, 3 weeks ago, it wasn't that bad of a case at all. And quite honestly, we won on some of the issues that we argued. So it was a good thing. But recently I got to use that case in another case that I had, and it benefited me. I mean, I knew that case back and forth because I argued it in front of the Utah Supreme Court. And so when I used it, another attorney tried to argue that it stood for something else that it didn't stand for. And I was able to refute their arguments just based on the fact that I had lived it. I had to argue it. And so, you know, it was good. But sometimes, yeah, sometimes as an attorney, you get things thrown to you that you don't want to do, but they can end up blessing you later on down the road. It's just kind of like baptism by fire a lot of the time.
So another question was, and we've started kind of some preliminary debating a little bit here and there, just some topics, and it gets a little bit heated at times. How emotionally driven do you get when you're arguing a case with someone else?
I think it's a, you know, it's a person by person, case by case scenario. For me, I think I do get pretty emotionally charged with some cases. There are some cases where you're like, you know what, it's interesting and I'm into this case, but you're not that invested. You know, if you argue a motion and the judge decides against your motion, sometimes it doesn't affect you that much. However, there are some cases where you spend so much time and you're emotionally invested in this case, so much so that when you argue it, you know, you start to pound the table, or you start to use your hands a lot more. You start to speak louder and become a little bit more agitated. But for the most part, I think a lot of attorneys, they can bridle that and they keep it pretty civil because you know, you have to remain civil in the courtroom. But I have been in court before, not on my case, but where I've seen attorneys get very animated and very angry. And there was one case in Kane County where I was down there for one of my cases. In a case before my case came up, two attorneys got in a very heated argument. And one of them jumped out of his chair, and the bailiff came over to him, and I thought he was going to restrain him. All he did was tell them to calm down. But this one attorney, I honestly thought he was going to get arrested right there on the spot, just because as attorneys, we can get heated, but at the same time, we have to maintain a decorum of civility and professionalism. And, you know, obviously we're human too. And so sometimes we do let our emotions get the best of us, but we're supposed to bridle it more so than our clients would.
All right. So does anybody else have some questions? One person asked, what was the least favorite thing about your job?
The least favorite thing. Well, I consider myself a litigator, so I prefer to be in court. So I would say the least part of the job that I like the least would be if I'm stuck sitting at my desk and answering phone calls or typing documents. I don't enjoy that near as much as I enjoy being in the courtroom, talking to the judge, talking to my clients, you know, kind of doing the litigation aspect. But there are some attorneys, I have friends from law school who they haven't been in a courtroom yet, and they love it.
Right.
They love to be in the safety of their office, no adversary staring down at them. They're just there content being in their office. But I prefer to be in the courtroom.
Yeah. Do you remember, you know Clayne Snow, right?
Yeah.
Okay. I spoke with Clayne the other day, similar thing, but he's a patent lawyer.
Oh, okay.
He does a lot more. Like he's working with intellectual property, I believe. So.
Yeah.
Intellectual property. Do you want to explain? Do you know much about intellectual property law? Or
we don't handle intellectual property law. I mean, I could explain it a little bit, but yeah, we don't touch it at all in our firm. So, I mean, but it's basically property rights, like, you know, if you're doing trademarks and stuff like that.
Yeah. But he said the same thing. He said in his firm they have one group that does all the litigation, and he's part of the group that kind of clocks in 9 to 5 and just sits in his office and he loves it.
Yeah. Yep.
So anyway, any other questions you guys have?
Akir,
what you got?
Akir's got a good one.
No.
Akir wants to know. No.
Oh,
Yeah,
Well,
yeah.
I think I could cut my hair. But,
How much do you get paid?
no, that's not a question you ask.
Yeah, you can answer the question.
Not near enough.
Yeah. It's not the case with all of us.
Yeah. For any of you that are thinking, I want to go to law school, make sure that you research it very well, because I will tell you this, that when I went to law school, in 2007 through 2010, that's when we kind of had the economy crash. My tuition for law school, $32,000 a year. And plus living expenses and everything else. By the time I got done with law school, I'd accumulated close to $200,000 in debt. I can honestly tell you that I do not make $200,000 a year right now. So I will be paying off the law school loans for years to come.
See, that college shouldn't be a debt sentence.
Well, anyway, yeah, Clayne, I talked to Clayne. Clayne was in a different boat. He got like a full ride to Stanford.
Oh, that's the way to do it. If you're going to do it, that's the way to do it.
But anyway, so we had some. Do you have any other questions?
Yeah. She right there. You can't see her.
You want to jump in?
She had a question.
Me?
Yeah.
Maddie had a question. I'll turn it so you can see.
Okay.
Right.
Was it?
I don't remember. I just saw it earlier.
Okay.
Yeah, I do have one.
So we had a question. How many years you went to school? I think you just answered that with 2007 to 2010. So it's a 3-year program.
Yeah.
And did you get your JD?
My what?
Your Juris Doctorate. Did you get your JD?
Yes. Yes, I did.
Okay. How many times have you lost?
How many times have I lost? Well,
Good
let's
record.
see. I guess if you look at it as in full cases, I don't think I've ever lost a case per se, because it's never as simple as win-loss. Like if you're a prosecutor, I guess you could look at it as a win-loss column type of ordeal, because if you're prosecuting someone and they get acquitted, then I guess you lost. But as a defense attorney, like I said earlier, my job is to get them the best possible outcome. So for example, if I have a client who gets arrested for, having marijuana on him, that's a possession charge, possession of a controlled substance. Depending on how many times he's been hit with that, it could be a Class B or it could be a felony. So let's say it's his first time ever. He gets caught with marijuana. He's talked to the police, admitted to the police that he's done it. So I don't have a lot I can do there, right? I can't take it to trial and hope for an acquittal. But what I can do is I can talk to the prosecutor and say, hey, guess what? I've got, John Doe here who just got his first possession charge ever. Other than that, he's an upstanding citizen. He gets good grades in school. He does all these great things. So instead of, having him do a guilty plea, let's do something that's called a plea in abeyance. And what a plea in abeyance is where you say, okay, I'll plead guilty, but if I do A, B, C, D, and E, then you'll let me withdraw my guilty plea and you'll dismiss the case. And it's called a diversion agreement as well. And so if I can get my client one of those, and then my client doesn't violate that agreement and fulfills his provisions, then guess what? At the end of the day, that possession charge goes away, it's dismissed, and it's as though it never happened. So
Right.
Technically speaking, you could say, well, he pled guilty, so I lost. But at the same time, once he achieves everything he's supposed to do, guess what? That case gets dismissed, and I count that as a win. So when you look at it that way, there's no really win or lose. But, I mean, it just depends how you look at it, I guess.
Right. Well, and again, with movies, we see this as like the win-loss thing, but if I'm reading you correctly, a lot more times it's more of a win-win, who has the best, like working together to get the right outcome together as a group.
Yeah. I mean, and in other cases, there are, I guess, more wins, losses. Like if I have a client in a family case who says, I want you to make sure I have my kids at all costs, but then the judge awards the kids to the other parent, I guess you could count that as a loss. But really, as long as they get to see their kids, that's all that matters. So I think it just depends on how the attorney looks at the case. I try not to look at it as a win-lose situation, because then if I do that, then it's harder to try and work with my clients if they view it as a possible losing situation.
Right. Okay, we had another question. Have you ever done any like youth work? I mean, do you mostly deal with adults, or do you ever do like juvenile cases?
No, I do. Yeah, I do a lot of juvenile cases. So
Okay.
I handle juvenile delinquency matters as well. If kids are if kids are getting in trouble in school, or assault charges, and they're under the age of 18, I'll handle those too. You don't see as much with private attorneys though, because generally speaking, when I was talking about public defense,
Right.
that's usually handled by public defenders, because most 16, 17-year-olds do not have jobs or do not have the money to hire their own attorney. So primarily that's handled by public defense. But yeah, I've handled quite a bit of it, and I actually like working with juveniles. I mean, it's actually a little bit more rewarding, because generally when you're a teenager and you do something stupid, if you do the correct things that you need to do to make it up, it's amazing to see the growth and how much they progress after that scenario occurs.
Kind of a wake-up call, and
Yeah.
which doesn't happen to adults as often. So.
Yeah.
Yeah, no, Mia had a really good question that I wanted to.
All right, sorry. I know we're taking a lot of your time. Is
No,
that
you're
okay?
fine.
All right,
Yeah.
you have a question?
How long does an average case last, like shortest to longest time?
Yeah, what's the average? She said, what's the average like length of a case you do?
Okay, well, I'll tell you this. For a divorce case or a family law case, it's a lot longer. And depending on who you talk to, the problem's either the courts, it's either the attorneys, or it's the parties. But it's usually those three that are getting blamed the most. But I've had divorce cases that have gone through from start to finish in about a year. But then I've had some divorce cases that are years. We're talking 6 or 7 years long. And that is, I'll tell you right now, unless the attorneys are getting paid a lot of money, which typically they aren't, usually that problem comes because the parties are refusing to work things out, or they're refusing to negotiate. And so therefore it drags it on. Criminal cases though, much speedier. You guys have heard of the right to a speedy trial, right?
Yeah.
So with that right, you also have the right to, a speedy case being resolved. So if it doesn't go to trial and you're talking about plea negotiations, you can usually get plea negotiations done within a couple months. If it's a real hot button issue, it could take longer, and you could be up to a year or longer. But typically speaking, in fact, I had a case today. I was in court today on an assault charge, and it was filed probably in June of this year. And we just barely got it resolved completely, and it's September, mid-September. So that's pretty fast. But divorce cases, family cases, contract disputes, civil things in nature, those things generally take longer, because you have a lot of pride involved. You have a lot of people that say, it's my way or the highway. I don't care how much it costs. I want you to make this person pay. And if you're dealing with that type of a client, I can guarantee you will always spend more money and spend more time than is reasonably necessary to try and resolve that case.
No question. Okay, one more question.
So since you deal with like marriage, divorces, and like custody and stuff, what's like the largest amount of kids that you had to like defend and stuff for the marriage, divorce?
So largest amount of, I don't know if you could hear, but largest amount of kids that you've had to deal with when it comes to a divorce case.
How do you do that?
Oh, largest amount of kids, probably not too many. Probably, I don't know. I think one case had maybe 3 or 4, but I mean, not too many. Typically, my cases have had 1 or 2 kids, maybe 3. It's not so much, I guess the biggest thing is with custody disputes, it's not so much how many kids and trying to determine which parent's best. a majority of it is actually trying to decide what's the schedule going to look like. So for example, if you have both parents getting, they're getting a divorce, but they live in the same city, that parent time's probably easy to determine, because it's like, hey, you go from block here to block there to the other parent's house. That's easy. The hardest thing is when one parent ups and moves to another city or another state, then you're trying to say, okay, we think both parents are good parents. They both deserve equal time. How do you make equal time if the kids are enrolled in school in Utah and mom or dad lives in California?
Exactly what my case is.
Yeah.
Yeah.
It's like, that's weird, because I was just going to ask that.
So well, Akira was saying his case is very similar to that.
So my mom lives here, my dad lives in California, so I only get to see my dad like once or twice a year. So like,
Yeah.
is that something that you have to work out in like the court or something that they did work out when they first got the divorce? Or is that something that just kind of happens?
Well, you work it out at the beginning of the divorce and you try and reach a resolution, but nothing stays the same, right? So whenever your parents got divorced, let's say hypothetically speaking, they got divorced when you were in elementary, okay? And so they say, hey, when he's in elementary, this type of situation is going to work perfect for his visitation. Well, guess what? Now you're older, you're more mature, you would have the ability to spend more time with your father in California. So then either one of the parties or one of their attorneys would petition the court to say, hey, guess what? This guy's older now. He deserves more time in California. We need to relook at this, Your Honor. And then the judge would look at it again. And if he determines that you do deserve more time in California, or that initial visitation schedule needs to change, then he can do that. He has the authority to do that. But if no one petitions the court, then nothing's going to change, and you're just stuck with the same visitation that you had from day one.
All right, so I got another question, kind of a little bit off topic what you're talking about, but how much of your time is prepping for the case versus actually being in the trial or speaking with the judge?
Okay. Well, so if it's a motion hearing where we're just arguing one motion, so for example, on that last question, if I were doing a petition to modify the divorce decree to try and get him more visitation with his father in California, I would probably prepare a couple hours to argue, maybe 45 minutes, So you over prepare because you may not get to say it all in court, but you over prepare. So maybe a couple hours for 45 minutes. Now, if it's a trial though, I'm preparing for weeks.
Really?
Depending on what kind of a trial it is. I could be like, I have a divorce trial coming up in December, and I've started preparing for that now. I do a little here, a little there, but it's one of those issues that I know when I go to trial on this case, it's going to be so messy and so ugly that I want to prepare as much as I can, because I don't want to be caught off guard by the other attorney at any moment, because then if that happens to me, then my client's going to suffer. So
now give me an idea, like prepare, what does that mean, prepare? Like researching older, like other cases, like tell me, what does that mean, prepare?
So to prepare, it's researching case law, it's researching the evidence of the case, it's going through, now in today's age with technology, it's going through a numerous backlog of text messages, Facebook pages, social media. I mean, you would not be surprised, you'd be surprised at how many people put stupid stuff on social media that will come back to bite them in a custody dispute, in a divorce case, in a criminal matter. We've had criminal matters where, and I tell my clients this all the time. I tell them the second they retain me, I say, get off Facebook, get off social media, don't post anything, because we've had things where people will be in trouble for DUIs. And then guess what? They'll go on Facebook and they'll say, look at all this alcohol I have so I can have a party. We're going to get so drunk and just blitzed and none. And guess what? The prosecutor finds that, and then I am less likely to help out my client, because the prosecutor's going to say, EJ, I'm not going to give you a plea in abeyance. Look what your client posted on Facebook. Look, they've got a beer in one hand and they've got their 2-year-old daughter in the other. And so if it's something like that, it makes it really hard. So I prepare by going through every amount of documentation I have just to make sure that I've gone through everything, so that if there is something that's damning to my client,
Right.
I'll have a way to refute it, or at least try to sidestep it, because some things you can't argue with, obviously. If there's evidence out there that directly points your client to doing something horrible, the best you can do is, pray for mercy from the judge and hope that your persuasion helps out. So.
Well, cool. Okay, anybody have any other questions? I know we're pretty close to actually our class being about done. So we have one more question.
Have you ever had to take a kid away from their family?
You know what? That's a good question. Before I went to law school, I actually worked for the Division of Child and Family Services. I was a caseworker there. And so my job was dealing with families and their children. And, in that aspect of the job, I had cases where I was saying, you know what, these kids should probably be removed from their home because their parents are doing terrible things, whether it's drugs or neglect or whatever it is. Then on the flip side, as a criminal defense attorney, I have been in cases where I have gone directly against people that I used to work with when I was a caseworker at DCFS. And, and there's respect there, so it's not like we get in arguments or fights. But it is interesting when you have both sides that you've been through and you've seen how each side is, it helps you out in how to try and resolve disputes and how to argue your points, because you understand where they're coming from and you also understand what you're trying to do. So in my position now, I'm trying to keep kids from being removed from homes, right? But at the same time, as a father, and a parent of two small girls, it's really hard for me to be able to say, hey, guess what? Keep the kids there in the home, even if I know full well that mom and dad are meth addicts and they're doing all sorts of stuff when their kids are there that they shouldn't be doing. So it just depends. But and maybe touching on that just to close, as an attorney, and this may be kind of what you guys were getting at initially when you're saying, hey, what if you have to represent someone you don't like? What if I have to represent someone that I know is guilty? I get that question all the time. What do you do if you know your client did it? What do you do then? Well, what I'm supposed to do is I have to protect their rights. So even if I know they're guilty, even if they've admitted to the cops and they've admitted to me that, yeah, I have 200 pounds of marijuana in the back of my car. There's nothing I can do to change that, right? But what I can do is I can protect my client's rights. So, for example, if the officer that pulls over that car, starts saying, hey, guess what? Get out of the car. I'm going to check your car. Well, did he have a search warrant?
Right.
Did he have probable cause? If he didn't have either of those, guess what? I can get that whole 200 pounds of marijuana quashed. I can get it suppressed. And if that happens, then I guess technically I've just helped a drug dealer get back on the street. But the point is we all have to make sure our rights are protected, because you never know, even though, police are good people and we love police, not everyone's a good person. And so you have to make sure that everyone's rights are protected. So that's my job as a criminal defense attorney.
Cool. All right, well, thank you so much, EJ. I really appreciate all the information.
Thank you.
So,
Thank you.
all right. Have a great
Thank you. Have a good class.
Yeah, tell your family hi for me.
Okay.
All right, we'll see you.
See ya.